Good morning. This hearing will come to order. I have to apologize for being late. There was a significant program celebrating 400 years since the first slaves were brought to this country over an Emancipation Hall, and I tried to show my presence and was late getting over, so I apologize for that. But without objection, the chair is authorized to declare recess at any time. I'd like to welcome everyone to the hearing. The criminal justice system relies on forensic science to identify and prosecute criminals and exonerate the falsely accused. Unfortunately, for too long, the science in forensic science was a misnomer. According to data from the Innocence Project, 367 individuals convicted of violent crimes across 37 states have been exonerated as a result of DNA evidence. Nearly half of these false convictions involve the misapplication of forensic science, most often because of the lack of science standards and training, but in some cases involving misconduct. I'm deeply troubled by the likelihood that these numbers represent just the tip of the iceberg. As revealed over many years of investigative reporting by the Washington Post, for decades there were people in this system who knew there were significant problems and stayed silent, or perhaps tried to speak up but were silenced by those above them. A 2009 report from the National Academies, Strengthening Forensic Science in the United States, A Path Forward, finally broke the silence and brought this issue into the public discourse. The central conclusion of the report was that the interpretation of the forensic evidence across many disciplines were severely compromised by the lack of supporting science and standards. The National Academies recommended a number of steps to improve accuracy, reliability, and validation for forensic evidence, with a focus on the role of federal science agencies, especially the National Institutes of Standards and Technology. In 2012, I joined colleagues in the Senate to introduce the Forensic Science and Standards Act. I continued to reintroduce that legislation, but it never received a hearing until today. As forensic science plays an increasing role in our criminal justice system, we are here today to explore how the Science Committee can help improve forensic science practices in the nation. We'll learn about improvements since the NIST report and an eye to the improvements that will need to be made. We will hear from the witnesses their recommendations on how to strengthen the existing legislation. This is an excellent panel representing diverse perspectives, and we have a lot to learn from you. We have all heard heartbreaking stories of men and women who have spent years, sometimes decades, in prison for a crime they did not commit. These wrongful convictions take a profound human toll on innocent men and women and their families and mar the reputation of the justice system. And that's not all. One study of 108 DNA exoneration cases found that 121 of the actual perpetrators went on to commit additional 337 crimes, including rape and murder. However, I'm encouraged by all of the new partnerships and efforts among the various stakeholders that were spurred by the National Academy's report. I look to my own state of Texas, which has a troubled history with false convictions, as exemplar for forensic science, transparency, and improvements as we can do. And if we can do this in Texas, we can do this anywhere. I look forward to a spirited discussion and to working with my colleagues across the aisle to move bipartisan legislation through this committee and I thank the expert witnesses for your testimony today. I now will recognize Mr. Lucas.
Thank you, Chairwoman Johnson, for holding today's hearing on the state of forensic science in the United States. Forensic science is the study and application of science to matters of law. As members of the Science Committee, we're focused on the science part of that equation, but we can't ignore the law either. Integrity of forensic science can have a profound impact on the lives of Americans who are victims of crime and those accused of committing a crime. The Constitution states only one command twice. The Fifth Amendment says to the federal government that no one shall be deprived of life, liberty, or property without due process of law. The 14th Amendment uses the same 11 words, called the Due Process Clause, to describe a legal obligation of all states. These words are a commitment to fair trials and judgments at all levels of American government. This is important because most forensic science methods, programs, and evidence are governed by state and local law enforcement entities, or covered by statutes and rules governing state judicial proceedings. Our task is to look at what role the federal government can play to advance the accurate, reliable, and fair use of forensic science. As forensic science plays an increasing role in our criminal justice system, it is important to make sure we're getting the science right and that all Americans have confidence in the fairness and integrity. DNA evidence has revolutionized the justice system. When properly collected and analyzed, DNA can be useful to identify criminals with incredible accuracy. DNA can also be used to clear subjects and exonerate people mistakenly accused of committing crimes. To date, over 350 individuals have been totally exonerated by DNA analysis. The science of DNA is well established, but there are many other areas of forensic science that are still evolving, such as human hair analysis and bite mark identification. The truth is, forensic science is more complex than what is portrayed on popular television shows. Even when the science is well supported, putting it into practice in the field is a challenge. In many small police departments across the country, law enforcement is not afforded the luxury of specialization due to the community size and caseload. Not all police officers can be experts in collecting and evaluating forensics evidence, and may not be able to utilize groundbreaking new tools. The National Science Foundation and the National Institute of Standards and Technology can help address this. Both agencies do important work on forensic science, strengthening fundamental research and improving standards for the practice of forensic science in criminal investigation. I have said before that many Americans may not know the critical role NIST plays in our nation's innovation. Today is another fine example. We'll hear more about their research in several forensic science disciplines and their administration of the Organization of Scientific Area Committees on Forensic Science. Through OSAC, NIST is bringing together experts in science, measurement, statistics, law, and policy to develop and evaluate forensic science standards. It is challenging work getting these communities to cooperate, and I look forward to hearing how that process is going and any recommendations to make it better. As the chairwoman stated, it has been 10 years since the National Research Council issued their report, Strengthening Forensic Science in the United States, A Path Forward. I'm glad we have this opportunity to hear what progress has been made since then and what work still needs to be done. We have a distinguished panel of witnesses today who will represent the science, law enforcement, and legal communities to help us understand the challenges and opportunities in forensics. I look forward to a balanced discussion of how we can all work together to ensure Americans' trust in the use of science in our criminal justice system. Thank you again, and I yield back, Madam Chair.
Thank you, Mr. Lucas. If there are members who wish to submit additional opening statements, your statements will be added to the record at this point. At this time, I'd like to introduce our witnesses. Our first witness is Ms. Susan Ballou. Ms. Ballou is the program manager for the Forensic Scientist Research Program within the Special Programs Office of NIST. Prior to her time at NIST, she worked as a lead serologist for the Montgomery County Police Department Crime Laboratory in Rockville, Maryland. She has obtained expert status in federal, state, and county circuit and district courts. She holds a Master of Science in Biotechnology from the Johns Hopkins University and a degree in criminal justice from the University of New Haven in Connecticut. Our next witness, Ms. Lynn Garcia. Ms. Garcia is the General Counsel for the Texas Forensic Science Commission, a position she has held since December of 2010. In this role, she assists the Commission with investigations, manages the Commission's laboratory accreditation and analyst licensing program, provides legal advice, and represents the Commission at various public meetings. She obtained her JD from Georgetown University Law Center. I would now like to recognize Mr. Lucas to introduce the next witness.
Thank you, Madam Chair, and it's my honor to introduce my fellow Oklahoman, Ms. Vicki Zemp Behenna, who serves as the Executive Director of the Oklahoma Innocence Project. She was previously an Assistant United States Attorney for the Western District of Oklahoma, where she served with distinction for 25 years. As a prosecutor, she was involved in many high-profile cases, including serving on the team that prosecuted and obtained the conviction of Timothy McVeigh in the Oklahoma City bombing case. The recipient of numerous awards in her career, and she's now in private practice teaching as an adjunct professor at Oklahoma City University School of Law. She received her bachelor's degree in journalism from the University of Oklahoma and her JD from Oklahoma City University School of Law. Welcome and thank you for participating today, Vicki.
Thank you, Mr. Lucas. Our fourth witness is Dr. Karen Kafadar. Dr. Kafadar is Commonwealth Professor and Chair of Statistics at the University of Virginia. She currently serves as the President of the American Statistical Association. She served on the National Academy of Sciences Committee that led to the publication of the 2009 report, Strengthening the Forensic Science System in the United States, A Path Forward. She also previously chaired the Organization of Scientific Area Committee's Statistical Task Group. Dr. Kafadar's research focuses on robust methods, characterization of uncertainty in the physical, chemical, biological, and engineering sciences, and methodology for the analysis of screening trials. She received her BA and MS from Stanford University and her PhD in statistics from Princeton University. Our final witness is Mr. Matthew Gamette. Mr. Gamette is the Crime Lab Director with the Idaho State Police Forensic Services, a position he has held since 2014. He previously worked in the Spokane Laboratory of Washington State Patrol. Mr. Gamette currently serves as an elected board member of the American Society of Crime Lab Directors, where he is president and chair of the Advocacy Committee. He has also served as chair of the Consortium of Forensic Science Organizations. In addition, he currently serves on the NIST Organization of Scientific Area Committee's Quality Infrastructure Committee. He received his bachelor's and master's degrees from Brigham Young University. As our witnesses know, you will have 5 minutes for your spoken testimony. Your written testimony will be included in the record for the hearing, and when you have completed your spoken testimony, we will begin questions, and each member will have 5 minutes to question the panel. We will start now with Ms. Ballou.
Chairwoman Johnson, Ranking Member Lucas, and members of the committee. I'm Susan Ballou, the Program Manager of the Forensic Science Research Program at the Department of Commerce's National Institute of Standards and Technology, known as NIST. Thank you for the opportunity to appear before you today to discuss NIST's role in forensic science. I will address 3 different ways that NIST contributes to forensic science: research, development of reference materials, standards, and guidelines, and convening the forensic science community. NIST established 6 focused areas of research: firearms and associated tool marks, digital and identification forensics, forensic genetics, statistics, toxins, and trace. NIST frequently collaborates with other federal agencies, including the FBI, DEA, DOD, ATF, and DHS, as well as state and local crime laboratories to identify key research areas. The release of the 2009 National Research Council report highlighted areas where forensic science research was needed. and made recommendations for improvements. NIST built on this report in areas related to strengthening the scientific foundation of forensic science examinations and focused on improving AFIS interoperability and application of statistics to firearm examinations. In 2012, NIST, based on collaboration with DOJ's National Institute of Justice, developed a process map of the steps involved in latent print examination. Important improvements have been made and process maps are being created for other forensic disciplines, including handwriting, DNA, and firearms analysis. Digital evidence is a growing area in forensic science. Ensuring the reliability of software tools used to extract data from computers and mobile devices is a critical need within the law enforcement community. NIST is actively assisting in testing computer forensic software tools. NIST also maintains the National Software Reference Library, which is used to improve efficiency in criminal investigation digital searches. NIST research over the last 30 years has resulted in many improvements in DNA measurement. For example, NIST developed standard reference materials, or SRMs, such as a human DNA standard. This SRM is used by DNA labs to make sure their instruments and methods are working properly, enabling accurate measurements of DNA markers commonly used in forensic laboratories worldwide for human identification. NIST continues to lay the statistical foundation for calculating matched statistics that can help in cases with evidence that contain a mixture of DNA from several people. To assist in firearms analysis, NIST has created a standard bullet and cartridge case to provide a calibrated measuring surface to ensure 3D surface scanning microscopes are properly calibrated. The SRM also improves interoperability between law enforcement agencies, which increased hits across state borders, resulting in law enforcement labs digitally comparing bullets and enabling confirmation that the same weapon was used in multiple crimes across multiple jurisdictions. NIST research into the forensic science field of trace work on paint, glass, hair, fibers, and tape is breaking new ground. Using scientific methods, hair could be profiled using protein in the hair shaft. In this way, two specific hairs, one from a suspect and one from a crime scene, could be compared and given a stronger probability of having come from the same person. To identify anonymous hair found at a crime scene, a library of cataloged hair could be created, much like the DNA database. NIST has conducted research into trace detection of opioids and other illegal drugs to validate the accuracy of the identification and quantification of controlled substances. NIST is also developing methods to help investigators detect drugs at crime scenes, in cargo, at transit hubs, and tools to identify emerging synthetic and designer drugs. Detecting trace amounts can prevent exposure of first responders to these harmful drugs and identify the types of illicit fentanyl that drug dealers may lace their supply with. This research can also help first responders in determining the source of an overdose and how to treat the overdose victim. 5 years ago, NIST established the Organization of Scientific Area Committees for Forensic Science, or OSAC, to facilitate the development and promulgation of consensus-based documentary standards and guidelines. OSAC has a broad representation of stakeholders from the forensic science, legal, law enforcement, and research communities, with more than 550 participants from 48 states. NIST stands ready to assist the forensic science community. Thank you for the opportunity to testify on NIST's work regarding forensic science, and I'm pleased to answer any questions you may have.
Thank you very much, Ms. Garcia.
Chairwoman Johnson, Ranking Member Lucas, and members. My name is Lynn Garcia, and I'm the General Counsel of the Texas Forensic Science Commission. Thank you for inviting me here to discuss the progress Texas has made in the 10 years since the NIST report was published. The Texas legislature created our commission in 2005 in the wake of a crisis at the Houston Police Department Crime Lab. At first, the legislature gave our commission one job: to investigate allegations of professional negligence and misconduct against forensic laboratories. Over time, the commission has evolved into an oversight body that crime labs, law enforcement, and attorneys all rely upon for fair consideration of scientific issues. We have 9 members, 7 scientists, and 2 attorneys, all appointed by the governor of Texas. Using the core values of transparency, accountability, and collaboration, The Commission has taken on major initiatives in many of the areas mentioned in the NAS report. For example, we recognize that national accreditation programs under ISO are important but not a panacea. We use our statutory authority to supplement the work of the accrediting bodies, including additional audits where needed. We also require forensic analysts to be licensed. In the rare case that an analyst commits professional misconduct in our state, he or she may face disciplinary action up to including revocation of the license. We maintain a code of professional responsibility for analysts and crime lab management so that everyone shares the same expectations. We provide ongoing guidance on challenging scientific issues, from DNA mixture interpretation to efficient analytical methods for distinguishing hemp from marijuana. We also act as a facilitator and translator between the scientific and legal communities. Texas law requires crime labs to self-disclose nonconformities. We provide an open and transparent venue for resolving them outside of the adversarial system. We also partner with the Court of Criminal Appeals to promote forensic education and training of judges and lawyers, and we recently worked with the Texas Commission on Law Enforcement to improve crime scene training provided to peace officers. Finally, and this is a recent development, we're partnering with NIST in two key areas. The first is in the evaluation of OSAC standards for implementation in Texas, and the second is with respect to improving existing accreditation programs for our laboratories. One area where we could use federal support is for forensic science research, such as the initiatives contemplated by H.R. 5795. State and local crime labs face tremendous caseload demands, thus leaving precious little time for research. While we strongly believe the oversight of forensic laboratories should be left to the states, increased support from the federal government for forensic research would be helpful not just for Texas, but for all states. We would also like to stress the need to reauthorize the Debbie Smith Act. This legislation dedicates much-needed resources to state and local law enforcement agencies to conduct forensic analyses of crime scenes, including untested sexual assault kits. I would like to close my remarks by reading a few lines from the murder trial of Stephen Mark Chaney from Dallas, Texas. Mr. Chaney was sentenced to life in prison and served 28 years. The lines I'm about to read are from the direct examination of a forensic dentist who testified as a state's expert. Question: can you express your opinion? Answer: with reasonable dental certainty and scientific certainty, I feel that Stephen Mark Chaney made the bite mark on John Sweek. Question: and you also testified that someone else in the world possibly could have made that bite mark. Do you have any odds? Answer: 1 to 1 million. Question: does that appear in the scientific literature? Answer: yes. On December 19, 2018, Mr. Chaney was declared actually innocent by the Texas Court of Criminal Appeals, the state's highest criminal court. The commission reviewed a complaint filed by Mr. Chaney regarding the bite mark analysis in his case. Our members examined published literature, listened to presentations from a range of forensic dentists, including those who support the use of bite mark comparison and those who do not. And after listening to all sides, the commission recommended bite mark comparison not be admitted in criminal trials unless and until sufficient data exists to indicate that such comparisons can be made reliably and accurately. While we understand and appreciate our commission is not a court, and gatekeeping decisions are ultimately the responsibility of the judiciary, we try to provide useful information to judges to assist them in making difficult gatekeeping decisions. What we found is that by and large, they welcome the information. The vast majority of judges want nothing more than to make the right call. They just don't always have the tools they need to do it. Texas is a law and order state, and with that core value comes great responsibility. The Texas legislature understands this. The governor of Texas understands this. Legislators from both parties have worked session after session to create meaningful progress when it comes to the quality of forensic science used in our state. Is it perfect? No. Do we still have work to do? Absolutely. But in reflecting upon the last decade, Texas has shown tremendous leadership in forensic science reform. It has been an honor for me to share that story with you today, and I'll happily answer any questions. Thank you.
Thank you very much, Ms. Behenna.
Thank you, Chairwoman Johnson and Ranking Member Lucas, and this distinguished members of this committee, for the opportunity to discuss with you the intersection of forensic science and criminal trials. My name is Vicki Behenna, and I became the executive director of the Oklahoma Innocence Project in October of 2015. Oklahoma City University houses the Oklahoma Innocence Project. As previously stated, I was a federal prosecutor for 25 years. As part of my experience as being a federal prosecutor, I had the opportunity to assist in the prosecution of Timothy McVeigh. That was my first experience with the use of forensic science in a criminal prosecution. In 2009, I had a personal experience where a close family member of mine was going through a trial where forensic science was hidden. Exculpatory evidence was not provided, leading to his conviction. It was that experience that caused me to retire as a federal prosecutor after 25 years and to join the Oklahoma City Innocence Project, because I understood from personal experience the effect bad forensic science or Brady violations can have upon individuals who are accused in our criminal justice system. The weight that forensic science plays in modern trials cannot be overstated. Lawyers, while we like to think that we know everything about our case, cannot know science as well as the scientists do. As a prosecutor, when a forensic scientist or analyst came into my office and explained to me what this forensic science meant and its value in the prosecution of the case I was trying, became increasingly important to me, and I relied upon that expert's opinion. What we have seen in Oklahoma through an individual by the name of Joyce Gilcrease, who was a chemist with the Oklahoma City Police Department, is that when forensic scientists and analysts overstate the interpretation of forensic science, when they overstate hair analysis, when they overstate and use bite mark evidence and tell a prosecutor that that evidence proves, that bite mark proves that this individual committed or was there and committed this act, we rely upon that, as I said before, because lawyers can never know the science as well as the scientists and analysts do. Juries in our criminal justice system are the triers of the facts. That's their role. They listen to the evidence that's presented, they listen to the expert testimony given, and they judge witness demeanor and credibility based upon their role of being the judges of the facts. When experts come into a courtroom and they tell the jury, this hair came from this individual, or they give a statistical number that this hair could only have come from this many individuals in society, jurors believe that. They rely upon that in making decisions. When bad forensic science is used, the results are devastating for those who are accused of crimes in our criminal justice system. What I see with the Oklahoma Innocence Project is that many times people serve decades in prison based upon bad forensic science. Not all individuals and forensic scientists are like Joyce Gilcrease, and I hate to keep coming back and using that as an example, but it's something that happened in Oklahoma, is present and as part of what's happened in our modern history. But we need standards. Lawyers need standards. Judges need standards. And we need to rely upon the forensic scientists when they're testifying in court are testifying honestly and openly about the science they've been asked to testify about. The Innocence Project has made numerous recommendations that are part of my written testimony, and I won't go over that here. But our criminal justice system is designed to seek the truth. It is designed to equally protect victims and the accused. Because of the highly persuasive impact of forensic science and forensic experts have on the scales of justice, it's imperative that the science is validated and that forensic experts are supported with the scientific resources they need, and that judges are properly educated in their gatekeeping functions. Thank you.
Thank you very much, Dr. Kafadar.
Madam Chair, members of the committee, thank you for inviting me here today. I'm Karen Kafadar, Chair of Statistics at the University of Virginia, also President of the American Statistical Association, which has 18,000 members from 93 countries. I was an author of the 2009 report, which emphasized the need for more collaborative research between forensic scientists and the physical, chemical, biological, and statistical scientists. The committee's request, I'll just talk about the role of the sciences and statistics in advancing forensic science and standards, progress since the report, challenges that remain, and recommendations to continue progress and overcome these challenges, namely centralized leadership, funding for research, and guidance to the courts. First, forensic science in general progresses through research collaborations. Statistics plays a key role in evaluating proposed methods and interpreting data. The NIST report highlighted these roles and urged stronger connections between the forensic science community and other non-forensic scientists and statistical experts, leading to more reliable forensic methods. What progress has been made since the report? First, Chair Johnson and other members of Congress raised awareness of this critical issue. Second, DOJ and NIST formed a National Commission on Forensic Science. Commissioners cooperated and issued effective and constructive statements on forensic practice and testimony. DOJ disbanded this commission after only 13 meetings. Third, NIST created a forensic science standards organization whose mission has been to endorse existing standards for forensic practice. OSAC is comprised primarily of those invested in the current system, with only a few researchers who could be considered as being at arm's length to the existing forensic science system. Thus, little change can be seen in the standards that OSAC approves. And fourth, with congressional allocation of funds for competitively selected Center of Excellence to focus on foundational research in pattern and digital evidence. Through cooperative agreement with NIST, this consortium of 5 universities has been interacting with forensic practitioners and crime labs and has achieved much practical research in 4 years, but the mandate is limited to research and training in only 2 disciplines. Challenges remain. The report from PCAST, by the way, in 2016, reinforced the continued shortcomings 7 years after the NIST report. Efforts are being made to address them, but key problems remain. Lack of centralized leadership by an agency with the expertise and commitment to develop forensic disciplines and enforce standards grounded in science with proper statistical analyses. A dearth of studies with honest demonstrations of validity and reliability, inadequate funding for these studies to support an independent agency, and lack of guidance to the courts on how to handle forensic evidence that is relevant, but at best inconclusive. With my colleagues, I offer 3 recommendations. I do not think any of them will be new to NIST. First, an existing agency must take the lead. The NIST report emphasized that this lead agency cannot be law enforcement. NIST has taken the lead in improving forensic science. It can continue to develop mechanisms to support validation and reliability studies for forensic methods, build connections with practitioners, and remain independent of law enforcement. Its agenda should be informed by the forensic community, but not be beholden to it. Second, the OSAC currently is composed of mostly forensic practitioners with few arm's-length researchers. It can approve existing standards, but cannot modify them. OSAC approved standards that have been based on past practice. This is not progress. Forensic standards cannot be issued if research underlying them has not been conducted. Real progress is more likely if OSAC units were closer to the 50-50 balance between forensic community representatives and arm's-length scientists, who together can identify research needed to improve them. And finally, more research is needed beyond 2 disciplines in the present Center of Excellence. Research in other disciplines may require more funded centers whose research agendas are coordinated. Work arising from these centers, especially regarding validation and reliability, should inform OSAC decisions even when they challenge existing practice. If these recommendations are adopted, we can have proper standards on which the courts can rely with confidence. In short, we have seen some progress, but more is needed. Without it, courts remain undirected, and we have false convictions and false acquittals. With proper leadership, the situation can be reversed. Thank you.
Thank you very much, Mr. Gamette.
Chairwoman Johnson, Ranking Member Lucas, and members of the committee. Thank you for the opportunity to come on behalf of the American Academy of Forensic Sciences and testify today. Since 1948, the American Academy has served a distinguished and diverse membership of over 6,000 members, divided into 11 sections of physicians, attorneys, dentists, toxicologists, anthropologists, document examiners, digital evidence experts, psychiatrists, physicists, engineers, criminalists, educators, researchers, and others. I am also here representing the Consortium of Forensic Science Organizations. CFSO was formed in 2000 and is an association of 6 major forensic science professional organizations with a membership of over 21,000 forensic science professionals. I am currently the Laboratory System Director for the Idaho State Crime Lab System, and since I started over 17 years ago, forensic science as a profession has evolved and advanced, quality management has intensified, and standards and development has increased. The National Academy of Sciences study in 2009 was a significant event in our community. The study supported the forensic science community's ongoing efforts to improve the practice and forensic science as a whole. With support from the federal government, we have implemented many of the recommendations from the report. Efforts such as the White House Subcommittee on Forensic Science, the National Commission on Forensic Science, the NIST OSAC, the PCAST report, and discipline-specific research and validation studies have advanced the practice of forensic science. Other federal efforts have been put in place to advance the science, such as the Forensic Laboratory Needs Technology Working Group, the Forensic Science Technology Working Group, the Council of Federal Forensic Laboratory Directors. These efforts are addressing currently accreditation and certification, quality assurance, standards development and implementation, methods and protocols, education and training, ethics, terminology, research, technology transfer, discovery and transparency, statistics, standardized language and reporting, and expert testimony. Participation has spanned at least 23 federal departments and agencies, thousands of federal, state, and local scientists and stakeholders. Since 95% of the forensic science that happens in this country is performed at the state, county, and local level, it is critical to include all forensic federal, state, and local partners. Federal working groups have worked on the accreditation of forensic science service providers, the certification of forensics examiners and medical legal personnel, proficiency testing, a national forensic science code of ethics, standards, research and development, and technology transfer. One particularly helpful initiative has been the NIST OSAC. OSAC works to strengthen the nation's use of forensic science by facilitating the development of technically sound forensic science standards and promoting their adoption. These standards are written documents that define minimum requirements, best practices, standard protocols, and other guidance to help ensure that the results of forensic analysis are reliable and reproducible. The more than 550 members are experts from federal, state, county, and local government agencies, academic institutions, and private entities with expertise in over 25 forensic science disciplines. OSAC is highly collaborative in their processes. OSAC efforts have expanded into identification and prioritization of research needs that can be accomplished at NIST, NIJ, and other federal agencies. The DOJ has developed guidance documents for uniform language in testimony and reports for all federal laboratories. While research, including black and white box studies, is increasing, more resources must be dedicated to bolstering the scientific framework and open access publication of findings. Findings for research and funding for research has been sparse at best. Data shows that most major forensic science providers are accredited and have quality control programs. Most forensic science practitioners are accountable to one or more codes of professional conduct. Our community has adopted many of the recommendations from a variety of committees, commissions, and boards. In conclusion, our needs for a successful forensic enterprise are fairly simple. One, we need continued support of the federal government to fund efforts to increase forensic laboratory and medical examiner capacity, capability, and training. Two, we need the OSAC codified at NIST with sustainable funding. Three, we need fiscal and operational support for laboratory and medical examiner office accreditation and forensic science provider certification. We need, finally, a coordinated and well-funded federal research strategy that includes close partnership of practitioners and researchers. Providers are seeing an unprecedented increase in the work needed to investigate criminal cases. A needs assessment of laboratories and medical examiners is imminent from the Department of Justice, and we understand that there are dollar figures associated with those needs. I would urge this committee to review those reports while contemplating any new legislation that may affect the operation of forensic science service providers. It is vitally important to the criminal justice system in the United States to properly resource forensic science in the United States. A healthy and robust forensic science provider network is important for this country to prosecute true perpetrators, exonerate the innocent, and provide closure for victims of crime. We thank you again for this committee taking this issue seriously and helping us address this issue. And I would also stand for any questions.
Thank you very much. We now will begin our questions part, and I'll yield myself 5 minutes. Ms. Garcia, I want to commend you for you and the commission for your efforts to date for transparency about the ongoing challenges and for your continued push for improvement. Texas is probably not the first state most people would think about as a model for forensic reform. Yet you have achieved significant improvements over the last several years. Can you offer any recommendations about best practices or core principles for achieving forensic reform that could apply to any state?
Thank you, Madam Chairwoman. I think one of the reasons we've had success in Texas is because, number one, we have a legislative process, as you well know, that is very up close and personal. And so the members of the legislature in Texas spend a lot of time hearing the stories from exonerees, real-life issues that come up about particular areas of forensic science that may have contributed in some part to a wrongful conviction. Those messages resonate, so that's part of it, our legislative process. But the main thing I would say is we have tried our best to create a culture in our commission where we take the adversarial process and set it aside to have a genuine conversation in a transparent manner about what are the issues that are being faced by lawyers, by judges, by the forensic scientists. The labs bring their issues to us in the form of self-disclosure, and we talk about them in a public meeting. And that goes a long way to understanding and resolving some of the hardest issues that we have. We don't shy away from reviewing things retroactively. If we've identified a problem, such as when the FBI came out and said they had all these problems with the hair microscopy analysis, we looked at all those cases. We don't shy away from that. Same thing with DNA mixture interpretation. And it takes as long as it takes, and we get the resources we need to address it, and we do it together. So hopefully that answered your question.
Thank you very much. Ms. Behenna, at the risk of inviting the joke of the Texas-Oklahoma rivalry, are there discussions in Oklahoma about studying the Texas model for best practices or that might be implemented in your state and others?
We are working, and I say we, the Oklahoma Innocence Project, is working with the State Bureau of Investigation to review cases, in particular where hair analysis was used and possibly could have resulted in a wrongful conviction. It is more of an ad hoc basis right now rather than a collaborative effort, which is what is going on in Texas. There is much discussion in Oklahoma about criminal justice reform. Part of that discussion is trying to do, in a more systematic way, review of cases where bad or debunked forensic science has been used and its effect on possibly convicting somebody who is innocent, but not systematically, as I said, as you all have experienced in Texas.
Thank you. The 2009 National Academy of Sciences report was the first organized voice of scientists, practitioners, and other experts recognizing the limitation of pattern evidence techniques and the urgent need to address these limitations. What are the most important advances in the use of application for forensic science in the past decade? And this is going to be for everyone. And the second question is, what in your view are currently the most significant weaknesses regarding the use of application of forensic science? And I'll start with you, Ms. Ballou.
I was happy to say that NIST realized that there was issues with the comparison of fingerprints and bullets, actually using what we call different techniques of the pattern evidence, and therefore establishing more of a measurement process where you would actually have an algorithm that was recognizing the comparison process and giving a numerical value to the examiner would increase the value of what they're seeing between those type of comparisons. And that's what the National Academies addresses, that it was more of a visual comparison by the scientists instead of having a numerical support.
Thank you.
I would say, in terms of most important, I think there was a recognition that the way it's been done for a long time through apprenticeship, you know, one person teaching the next person who teaches the next person about a technique, recognizing that that is not the best way to go about a scientific analysis, that was important. In Texas, what we realize is that is not the fault of those who are doing the teaching or those who are receiving the information. So trying to address those issues in a blame-free way has been very helpful, but we took the lead from the NAS report. In terms of weaknesses, people are just, they're trying so hard to get through casework, they just need more support.
Thank you. My time has expired. Mr. Lucas.
Thank you, Madam Chairman. Ms. Behenna, we're grateful for your perspective here as a legal practitioner with a long and fruitful career in Oklahoma, including being on the team that prosecuted the Oklahoma City bombing case. But as a former prosecutor and currently a litigator, you've sat on both sides of the courtroom. Can you expand for us with some thoughts about what information would be useful for lawyers and judges to determine the validity of forensic evidence, and how to judge the qualifications of that forensic expert witnesses? Because these are issues you've dealt with.
So
And that's a very open-ended question. I understand that, but
it is. With regard to educating lawyers and judges about forensic science and its validity, I guess is a better way to phrase it, I think that has to come through education. As I told you before, as a young prosecutor, when an analyst came into my office or a forensic scientist came into my office and they said, this test means this, or this comparison means this, I took that without a question. And so I think it's important, and I think there has started to be discussion amongst lawyers, prosecution and defense lawyers, about sometimes we don't get it right, and sometimes science needs to be validated and it needs to be tested. So I think that's the most important piece as far as educating and talking to practitioners. We have to rely upon forensic science, as I said before. With regard to, I think it's important for judges, as I said in my written testimony, have a gatekeeping function. Before any expert can testify in a criminal proceeding or a civil matter for that matter, a judge has to evaluate the credentials of the person testifying and evaluate the science under 702, 703, the rules of evidence. But sometimes judges as well are not well educated on the validation or lack of validation of certain scientific techniques. And so I think in that respect, even though judges will continue to have a gatekeeping function, they need better education.
Mr. Gamette, let me turn to you. Idaho, like Oklahoma, is made up of many very rural communities. And there's special challenges in collecting and analyzing forensic evidence in rural communities. I assume Idaho is much like Oklahoma. My county sheriffs and my deputy sheriffs, my local chiefs of police, and their patrolmen literally are jacks of all trades. They do everything in these little communities. What recommendations do you have for ensuring that no matter where a crime occurs, we can have confidence in the way forensic evidence is handled?
Thank you for the question. I do see challenges in our rural agencies that we try to address first by direct training. So we send out our staff, we send them from the crime lab itself, and we educate these officers. We work together in partnerships. We collect evidence alongside of them, which I think is mainly important there. We want to prevent any unequal access to justice. So meaning a small community should not have less access to forensic services than you would have in a major metropolitan community. So we need resources to be able to put into all of these local communities, training, education for these officers, early training at post and those sort of things to be able to address these needs that they have.
Because literally in Oklahoma, my local law enforcement in many cases on the city, county level depend on the Oklahoma State Bureau of Investigation. And by the time you have an event occur that requires that kind of data collection, it can be an hour or two sometimes before their specialists can get to the field to some different part of the state. And this information does deteriorate after all. In my final moments, I'd like to turn to Ms. Ballou and discuss NIST being given the challenge of bringing scientists, law enforcement, and lawyers together to achieve consensus. Tell us how that process is working, putting all these various minds in the remaining time together.
So you can imagine when you set up a new organization that there will be bumps in the road as you progress. And it was a learning experience. We found with the OSAC, with the size of it, 550 members, actually it was a little larger when it first started, is that bringing everybody's personalities, expertise together, and those who actually indicated that they learned a considerable amount from being part of that organization as to what they initially thought was an easy task to do. And after listening to the other experts, whether it was in statistics or academia, they realized there was a lot they needed to learn also. And so at this point, NIST has learned that there are some changes that are needed in the OSAC process to make it more fluid and to obtain faster and increased results from it.
Expired, Madam Chairman. Yield back.
Thank you. Ms. Bonamici.
Thank you. This is a fascinating and important topic. I appreciate the expertise of all the witnesses. The right to a fair trial and the presumption of innocence are real cornerstones of our criminal justice system. And we know that jurors and judges and prosecutors and defense attorneys all rely on this scientific evidence by forensic analysts. It's labeled expert testimony, as Ms. Behenna noted. That gives it a highly persuasive impact. But we know that forensic evidence is not always reliable. My home state of Oregon, there's a lawyer named Brandon Mayfield. He lives not too far from me. I know him because our kids went to school together. After the 2004 train bombing in Madrid, Spain, Brandon was arrested and incarcerated based on fingerprints. His fingerprints were on file because he served as a lieutenant in the U.S. Army. He was incarcerated for a couple of weeks. The FBI broke into his home, tapped his phones, went through his garbage. Later, a couple weeks after Brandon was incarcerated, the FBI admitted it made a mistake, despite the fact it was later revealed that the Spanish authorities had told the FBI apparently multiple times before his arrest that the fingerprints were a negative match. Now, the government eventually apologized and paid Brandon and his family a couple $1 million, but I'm not sure that Brandon and his family will ever fully recover from the trauma they went through. It affected the whole community, but certainly him. So my point is that this is a really critical topic that comes up in many ways. I want to follow up on Ranking Member Lucas's question about training for judges and lawyers, and I want to ask about current training models and whether they could be scaled nationwide. The Federal Judicial College provides training for federal judges. The National Judicial College provides training for state judges. They're already providing forensic science training. Is there anything more that either organization can and should be doing in this area? Ms. Garcia, Ms. Behenna, I think might answer that.
One thing we're trying to develop in Texas based on feedback from our judges is actually a resource that they can access from the bench. Because as as Ranking Member Lucas mentioned, some of them are in very rural parts of the state. They cannot physically make it to the judicial conferences and the trainings. So we're trying to bring the resources to them.
Interesting, thank you. Ms. Behenna, do you have any thoughts on that?
No, I really don't, and it's, I mean, I wasn't aware, I knew that there was some training that was going on, at least on the federal level, not aware of the state, but, I mean, I would rely upon, obviously, Ms. Garcia with her.
Thank you. I also wanted to talk a little bit about one of the recommendations from the NIST study, the 13 recommendations for improvements. One of them is fund research on sources of human bias in forensic science. I wonder if you could talk a little bit about that. There was a suggestion during Brandon Mayfield's whole event that there was bias because after Brandon married his Egyptian wife, he converted to Islam. So there was some suggestion that his son was taking Spanish. So when they found the computer, there were just a lot of things that were alleged to be caused by bias. So anybody want to address the extent that human bias affects these cases? Mr. Gamette and then Ms. Behenna.
I can say that right now, practitioners are actively working on this issue. There are several laboratories, including Houston and Phoenix, Arizona, where they're working on human bias with researchers, performing research in the laboratory, putting precautions into place to address this very issue.
I think that's something that fascinating. Maybe we can follow up in another hearing. Ms. Behenna, your thoughts on that? Or Dr.
Kafadar. Yes,
Kafadar.
thank you. The Center of Excellence to which I alluded and where I'm working, I participate as well. Some of the projects involve trying to assess the level of bias and how you can modify the presentation of the materials to minimize the bias. There's also, in the OSAC that we mentioned, there are 3 resource committees, and the last page of my testimony shows the organizational chart. There are 3 resource committees, one of which is human factors, and they try to assess any of the standards that come through to ensure that there is minimum bias in them.
Terrific. Ms. Behenna, did you have a thought on that as well?
Just quickly to follow up, and that is that I think that a forensic scientist's independence, and understanding that he is independent or she is independent will be helpful as well in eliminating bias.
Absolutely. I see my time has expired. I yield back. Thank you, Madam Chair.
Thank you. Mr. Posey.
Thank you very much, Madam Chair. In preparation for this hearing, I contacted the sheriff in a county where I lived and asked him for his thoughts or anything that I might be able to add to the conversation based on his experiences. And this is a statement that he gave me that I'd like to enter into the record. Thank you. As a career law enforcement officer with over 39 years of public service, I applaud the AG Sessions' position to disband those who seek to weaken the criminal justice system with the creation of the National Commission on Forensic Science. Ending a so-called group of advisors made up of attorneys and scientists whose sole purpose was designed to discredit and reject reliable and admissible forensic evidence was the right thing to do then, and it still remains true. What should be discussed is how our federal law enforcement partners can help with forensic funding to expedite the lab submissions and eliminate untimely evidence backlogs. And so, having submitted that, I'd just like to start with Mr. Gamette, ask what you think we can do in that regard to help eliminate those backlogs. I know I've heard some discussion say it takes so much time, but you know, what would be the best way to eliminate the backlogs?
I think there's several issues there. One is in funding, and Coverdale is one of the main options that you have for funding in the laboratories. That Coverdale funding goes directly for instrumentation, for personnel, and other things that will directly impact the backlogs significantly. The other thing is in training. What we need is a bridge training to get people from education directly impacting the crime lab turnaround time. So we need a better transition plan to get those students from college into the laboratory. Sometimes it can take 6 months to 2 years to train those people, and that's not helpful when we need to eliminate the backlogs today.
Okay. Now, do you see that we have an adequate crop of aspirants for those positions with an awful lot of TV programs, Neil, dealing with these subjects? I would think there'd be a whole lot more public interest.
We do have a number of applicants for every position that we advertise. Sometimes we have a problem getting them through the background and polygraph process, to be honest, but we do have a number of people that can take those jobs. It's a problem of transitioning them from their college education programs into a very specific niche of science.
Very good. Thank you. Doctor?
You were asking what can be done to reduce the backlog?
Yeah, just your thoughts on it.
So I used to work at Hewlett-Packard Company, and they would continue to, do processes. And what I often found is that when we designed statistical experiments to identify the factors that were affecting the sources of variation and the yield, the percentage of proper products that were being outputted from the process, they actually saved a lot of time.
Okay,
So it was a matter of process control.
thank you. Ms. Berthet?
I won't profess to know how to clear a backlog. I will tell you that I hear from my friends at the OSBI who complain all the time about their backlog and forensic testing. It's a matter of resources.
Thank you. The Texas legislature has heard the same complaint that your sheriff made from various members of law enforcement around our state, and I'm very happy to report that this year they've really focused on it. They have funded the transition that Mr. Gamette spoke about. They're funding Sam Houston State University, the University of North Texas Health Science Center, to take those students and really get them bench ready faster and more efficiently. They are also dedicating a lot of money to Texas DPS to help them reduce the backlogs. So I think, and they're expecting results. So it will be interesting to see what happens during the interim and the next legislative session.
So the state has taken a lot of responsibility there, clearly.
Yes, sir.
Okay, thank you.
NIST has the opportunity to look at the actual processes that are in place in the crime labs. Therefore, we hear from the scientists as to where they actually have the difficulty. Do they need a quicker version of a particular methodology to assist in expediting the analysis of whatever the evidence might be? And we had success with that when the DNA was coming on board, specifically with 9/11. They needed a method that was quick on determining what possible DNA existed in the dust that was collected at the site, so NIST took it upon themselves to look at a different type of methodology or procedure. And we continued to do that and look forward to working with scientists on areas where they need to look at the backlog areas or the little log jams that are in the analysis process.
Well, thank you all for your good answers, and time has expired. I yield back.
Thank you very much. Mr. Lamb.
Thank you, Madam Chairwoman, and thank you to all the witnesses for being with us today. I also used to be a prosecutor before I was in Congress, and actually one of the biggest cases of my career, I consulted an expert from NIST, which helped us kind of push the case over the line. We had really high-quality fingerprint evidence, the science for which has come under debate, as Ms. Bonamici talked about, but it kind of is what it is. The issue in our case had more to do with the creation of a digital image of those fingerprints, which is a newer area of science in the law and was like very much under attack. The reliability of those images, whether they're clear enough to really make a match and that kind of thing. And it was somebody from NIST that we talked to and consulted with for months and months and months and got input on that really allowed us to prove the reliability of what the FBI had done in that case. So it was a real success story, and for me kind of shows how when you have non-traditionally, or I guess scientists that are not traditionally connected to the criminal justice system weighing in on some of these topics, it can really strengthen the underlying practice of forensic science. So I guess my question is, if the NCFS has been disbanded, for lack of a better word, but NIST remains engaged in these subjects and wants to make other contributions, is NIST kind of the home institution for integrating forensic science and traditional and emerging science now to make sure we still get those same kind of results going forward?
My honest answer would be I'd love to see that, but what actually happens is NIST is so involved with all the federal agencies and the scientists within them, and we work collaboratively as to where are the difficulties to expand on the research. But NIST is also a part of the Council of Federal Forensic Laboratory Directors. So we sit at the table with the directors of all the federal agencies to listen to what the issues are, what are the concerns, where do they need additional measurement science applied? And in addition, the National Institute of Justice has held 2 meetings now, which the sole point of these meetings is for every agency to list the research projects that are taking place so that agencies can see where they can collaborate on a particular project to stop duplication and to make maximum use of the federal budget. So in that point, I don't say NIST is taking lead. We're more part of the collaboration of agencies within the federal agencies.
And do you feel like the institutional framework is such that you're getting close enough collaboration, particularly with those engaged in criminal investigation and prosecution, to be able to continue to play that role?
We are, and I believe the OSAC is doing a wonderful process of updating even NIST with what the state and local needs are, which of course being in the federal arena, we don't always hear. So having them as participants right at our doorstep bring us back to where their concerns are and at that level.
Thank you. Dr. Kafadar, you kind of touched on this a little bit in your testimony as well. Could you just weigh in on the role of NIST as it stands today in the absence of NCFS and maybe where you see things going forward?
Yeah, I used to work at National Bureau of Standards, which of course became NIST, and I agree, it's a very collaborative organization. That's the sense of the scientists that work there. So I think that the kinds of roles that Ms. Ballou was describing are consistent and should be encouraged. Regarding the interaction with the various disciplines, and I agree that OSAC has been very useful in pulling together a lot of people.
Great. And I just wanted to ask about one last topic, which was the reference, Ms. Ballou, to the work you all are doing on detecting trace amounts of opioids, and particularly synthetic opioids. I have a bill that we're circulating now, trying to gather support for, called the POWER Act. There's a companion part in the Senate as well that Senator Sherrod Brown is pushing. And essentially, we're trying to get opioid detection equipment in the hands of more local first responders and crime labs that can detect fentanyl and the synthetic versions that are coming out, because a lot of times the existing equipment might detect heroin but not fentanyl. So just wanted to flag that for you. If there's anyone at NIST that wants to weigh in on either of our bills or suggest ways that we could make them even more comprehensive or help law enforcement more, particularly as you discover new synthetic analogs, I think this is going to be a problem for us for a while. Please contact my office.
I appreciate that, and we will be in contact.
Thank you. I yield back, Madam Chairwoman.
Thank you very much, Mr. Weber.
Thank you, Madam Chair. Boy, this is interesting stuff. Mr. Gamette, I'm going to start with you. Reading through your remarks and stuff, you mentioned that I think the AAFS was founded in 1948. And you've come along, I mean, there's been a lot of, I guess we've come a long ways because we didn't have a lot of the DNA and the technology that we have now back then. So it's very interesting to me, and I had to be away from the hearing for a bit, so I apologize if this is redundant. Is there a national crime info system on DNA that everyone can feed into different states, different counties, different agencies, so that the nation as a whole knows where that information is located?
Yes, there is a very extensive DNA database system in this country run by the FBI through the Department of Justice, and all local and state agencies that qualify meet the FBI requirements. They have to go through very strict quality assurance categories and other things and be audited, but they can upload data that can be shared between the states, both for arrestees and also for case data, so that that data can be compared. We do it every day.
So you call it case data. Of course, there's all kinds of DNA evidence, right? You could call it a fluid, a hair, I don't know, whatever, skin, whatever else. How do you maintain the integrity of those? And do all those other agencies have to go and examine those personally?
The profile that you'd be looking at in CODIS, or the National DNA Index System, would be a series of numbers. And so those numbers are compared to each other digitally. All that work is done in the database itself. And so the states generate a DNA profile from whatever type of evidence it is, whether it's biological, from blood, hair, saliva, anything could be entered. But we develop the profile, and then the profile is compared in the index.
So this may be a legal question. So in a case, does someone, does the law enforcement agency have to physically see that evidence, or it's just the, Ms. Garcia, you're shaking your head no. So they can go there and they can get the numbers rather, and that's admissible in court, and you don't have to actually have that evidence. Is that accurate?
So we have the evidence. The evidence will be collected at the scene. It comes into the laboratory. The evidence will be examined. Sometimes you might see the blood. Sometimes you might not. It might
So
be
that
minute.
evidence is still maintained in each particular jurisdiction?
It is.
what you're
Generally, it
saying.
comes into the state to be examined or to the local to be examined, and then it goes back to the agency once it's been examined and a DNA profile has been developed.
Okay. Thank you for that. Ms. Garcia, you said that you were hoping to develop a resource for judges they could use from the bench. What's the progress on that?
So right now, we don't, we're just starting to outline it. We just got funding to do this, so our fiscal year starts September 1. We're developing that, and hopefully we'll be able to share it with other states when it's done.
Congressman Posey read an interesting statement from his sheriff. What did you think about this sheriff's statement?
I understand that perspective. There are many members of law enforcement in our state who would share that. For someone who is out in a rural area with not much support, what's going on in Washington is very, very far away from the reality of what they have to contend with day in and day out. So we've made a special effort to work with law enforcement in more rural jurisdictions to make sure that whatever policy initiatives we envision from Austin, which also feels far away for some jurisdictions.
I spent 4 years there.
Yes. That those are doable, achievable for smaller agencies. And they will tell us when we are off course, and we will do our best to make course corrections.
Is there, and this is a question, and I have about 40 seconds left, is there one particular entity that sets the standard for, call it whatever you want, forensic, my son's in FBI, I think he deals with forensic data from financial crimes and stuff. So I know forensic is kind of a broad term, I guess, but in forensic data, if it's DNA and all those kinds of things, who sets the standards so that forensic people are qualified? Who does that? Ms. Ballou, you're awful quiet.
It depends on what area in forensic science you're looking at. As you already mentioned, FBI. So FBI sets the standards for DNA submission of profiles. So everyone looks to them for what do I have to meet to get that in. But for what each individual has to meet to, say, be certified in the profession or for their agency to be accredited, I would say everybody's kind of on their own on that one, on deciding what the agency expects to see in their employees and in their divisions and departments.
But Ms. Garcia is putting that together so that she could have that to offer to judges.
I did want to make a comment. In Texas, you must be.
You looked like you did.
So in Texas, we're the only state that requires a license to practice. So you must fulfill certain criteria that the legislature has set forth.
And there's 87 different entities that are Texas recognizes, and 40-something are outside of Texas, and 40-something in Texas.
Yes, sir.
Okay. I'm way over my time. Thank you for your indulgence. Thank you, Madam Chair.
Thank you. Ms. Horn.
Thank you, Madam Chair, and thank you to our panel of witnesses. And I would be remiss not to say it's good to have a constituent and resident of Oklahoma's 5th District. So, Ms. Behenna, I'd like to start my questioning with you. I think in your testimony, especially looking at the intersection of forensic science and criminal trials and how we do our best to ensure that the science is good and that we're finding that balance in the courtroom. It's been touched on in a couple of the other previous questions that we need to train judges, we need to train attorneys, and your transition from prosecutor to head of the Innocence Project is an interesting one. So My question is, in what kind of training and way can you overcome the hurdle or the predisposition of accepting the information just as it's given to you, or helping prosecutors and judges to understand their role in this process?
The greatest resource that I have right now is, quite honestly, the State Bureau of Investigation, the OSBI. We work very closely with the State Bureau of Investigation. If I have a question about a DNA report that came from a smaller county in Oklahoma, I can call the OSBI. I feel that they are independent scientists, and they're there to help anybody, whether it's a prosecutor, defense lawyer, or somebody at the Innocence Project. So there is not, again, a system in Oklahoma. I hope to resolve that sometime soon. Not as soon as, obviously, Texas has gotten on the ball with this, but hopefully that there is a resource like the OSBI that defense lawyers can contact and prosecutors can contact and questions things that they are told by their analysts and their experts.
Thank you. And to follow up on that for a moment, you mentioned a system and the progress from the Innocence Project. Have you noticed an impact of organizations like the Innocence Project or other organizations like the work that's being done in Texas informing trials and prosecutors, especially in places like Oklahoma where we have a significant problem with incarceration and clearly and sadly some high-profile cases of misuse of forensic evidence?
When I left the U.S. Attorney's Office and explained to people that I was going to go do defense work and be the executive director of the Oklahoma Innocence Project, I think my friends on the prosecution side, both federal and state, thought I had lost my mind. But I constantly engage in conversations with them to help them understand all of us have one goal, and that is to see that justice is done. That's a statement that I learned as a very young prosecutor at the Department of Justice. My role was to do justice. If that meant somebody was acquitted, so be it. Justice was served. And so we're beginning this conversation in Oklahoma about justice is the most important. I feel because of this personal experience that I have, maybe I have a little more credibility when I tell people we need to make sure we do it right. They seem to listen. So it is my hope that in the future, at least in Oklahoma and around the country, people will understand that it's the importance of justice. That's what we're all working toward.
Thank you. And Ms. Garcia, I wanted to ask a little bit more about effective procedures and how that can translate. Clearly, Texas has put in a lot of work to other states that may not be as far along, and what the most effective procedures have been to identify mistakes, fraud, and bias on the front end if states or other places aren't able to fully implement the same type of system that Texas has.
So Texas took the language in the Paul Coverdell law very literally, and they created an agency that investigates allegations of professional negligence and misconduct. That process and doing that transparently is how we started, and doing it fairly is the single best tool we have. Most states do not do that. They assign the task either to the AG or to an inspector general or something like that. But we have a commission with dedicated scientists who do that. And so the issues get vetted in a much more thorough way. That's where I would start in any state.
Thank you. I yield back.
Thank you very much. Before we go to the next questioner, let me express my appreciation to you, Ms. Behenna, for being here. I know you're going to have to leave soon to make your connections. You've been a very important witness, and we appreciate you being here. Dr. Babin.
Yes, ma'am. Thank you, Madam Chair. Appreciate it. And I want to tell all the expert witnesses thank you for your testimony today. It's fascinating. The use of forensic science has changed the way that we're able to study crimes and prosecute wrongdoers by providing more factual clarity in the evidence that we collect. The accuracy that has been brought to the courtroom since the introduction of forensic science is really pretty astounding. And I noticed in your opening statements in 2016 where the Texas Forensic Science Commission issued a decision recommending a moratorium on the use of bite mark evidence in future criminal prosecutions in Texas. I remember that. I practiced dentistry for 36 years in a rural area in East Texas, and I remember close to 20 years ago, our sheriff's office brought a container of skeletal remains by my dental office and asked me if I would help in trying to establish an identification. And I did my report, and they brought. I told the chief deputy. I said, "Well, I've done everything I can do. I have to have some comparisons." And I thought it'd be 6 months, and just a few days later, he brought me several dental records from other dental offices, and we made a positive identification. And sadly, they were never able to solve that case. But the family did receive some closure about what happened to their young son. It was a U.S. Marine who had been home on leave. So anyway, I thank you very much. It's certainly an important aspect of our criminal justice system. And you had mentioned, several of you, about how long it takes to be trained and certified to be a forensic scientist. I know how long it takes to become a dentist, although we do have specialties in forensics and dentistry, and that does take a little while longer. But did I hear one of you say it took about 2 years to get trained up to do this? You said that, Mr. Gamette?
Yes, sir. It can take somewhere between 6 months to 2 years is generally a training period that we would quote.
Okay. So the training do you have just academia, universities and colleges, or is this kind of like a vocation, or what type of 2-year training does that entail?
We hire scientists to work at our laboratories, so generally they will have a 4-year degree or a more advanced degree,
Okay.
master's degree, PhD
Great.
in the science that they're working in.
Okay, thank you. And I have the privilege of representing a Houston district that stretches all the way to Louisiana, by the way, and I want to just take a minute to commend the Houston Forensic Science Center. HFSC was an early adopter of high standards approved by the Organization of Scientific Area Committees of Forensic Sciences, of which many of you know is administered by NIST, and it has strengthened this nation's use of forensic sciences. And Ms. Garcia, you're a Texan. Do you have any recommendations or ideas on how NIST could build off of their ongoing relationship with states to better their systems and make improvements?
Yes, sir. Actually, we've invited NIST to our last 2 meetings, and we are trying to follow in HFSC's footsteps. As you mentioned, they adopted the standards early by working with all of our labs so that we take the same position statewide. And I think what NIST is going to need to do is go state to state and work with the responsible laboratories to make that happen everywhere. One thing I just wanted to note quickly is with respect to human identification using dental records, we have no issues with that.
Oh, yes, I understand.
Okay,
That's
just
right.
to make it clear.
But, I graduated from dental school a while back, and I remember when bite marks were supposed to be positive proof, and that all went out the door, at least in the state of Texas in 2016, so I understand. And Ms. Ballou, would you care to comment on that as well, on the with NIST and ongoing relationships with states?
So one of the activities NIST has taken under their wing was to request the NIST scientists to actually visit and take part in crime laboratories. And we've done so with the Maryland State Police, Montgomery County Crime Lab. Those are both fairly close to the Gaithersburg campus. And we've also visited several agencies in New Jersey and I believe Pennsylvania as well. And it has turned to be a real eye-opener to our scientists. When I first arrived at NIST, coming from a crime laboratory, I was asked to help the research move faster to be applied into the actual workings of the crime laboratory. And when I was shown some of the results of the research, I said, well, why are you using those items to test? And they said, well, these are the pure items we always test to determine whether the technology works. I said, well, let me put some spit on it, dirt on it, and some other things, and that would represent what we truly receive from the crime scene. And so it's been a real educational process, and NIST has really expanded the activities that have taken forth on this.
Thank you very much. It's fascinating. I could ask all of you questions for about an hour, but running out of time, so I'll yield back. Thank you, Madam Chair.
Thank you very much. Dr. McNerney.
Well, thank you, Chair Lady. And I want to thank the witnesses. I mean, this is very informative testimony, and I hope we can sort of change that into federal law in a positive way and federal funding too. So, again, I thank you. There is an intersection in the discussion with the idea of bias and explainability with artificial intelligence. Ms. Garcia, with the advances in computational forensic science, such as probabilistic genotype for DNA analysis and algorithmic firearm analysis, with this replacing human analysis and interpretation of evidence, can we maintain a defendant's constitutional right to cross-examine and challenge evidence against them when the evidence was produced by computers?
Thank you for the question. I think there's a misunderstanding about probabilistic genotyping in particular, that there is no human element there. There actually is. We've been looking at that very closely in Texas. We are an early adopter of probabilistic genotyping. I do think that analysts need to understand what the software is doing. They need to be able to answer questions on cross-examination about what the software is doing. It should not be used as a black box to plug information in and just get out a result. We're just now working on a couple of cases where we saw problems in the way the analysis was done, and we're using those as learning tools to help the labs understand that it is not a black box and there are still human judgment calls that are made. No analyst should testify if he or she does not understand what that software is doing.
Thank you.
Hope that answers your question.
So that should be the defendant's toolbox is, hey, this stuff comes from a black box and we don't have any way to cross-examine.
I would say that at least in Texas, the type of software that the labs are adopting, there is plenty of room for defendants to ask questions about what's going on underneath that. It's not actually as much of a black box as I think people think it is.
Thank you. Ms. Kafadar, how should forensic standards evolve to address not only advances in the science but implementation of forensic methods in software?
Implementation of
forensic methods
yeah.
in software.
So I actually was glad that you asked that question to Ms. Garcia about probabilistic genotyping, and I agree with her answer that there are software programs that could be used to give objective, less subjective output. I think the challenge is in making those algorithms transparent. Right now, I think number of the algorithms used in automated fingerprint identification systems remain proprietary. And then also, I think one of the real things that we want to do with that output is try to put some characterization as far as how likely is the output. Is it something that could apply to 20% of the population or only, 1 in a million? So it would go a long ways towards making a more objective assessment of what was the output of the software.
Well, do you have concerns about the ascendancy of artificial intelligence in forensic science?
In general, I think there's a lot of statistical foundations that needs to be applied to artificial intelligence algorithms. I think there have been a number of articles about that, and I would agree that there are a couple of aspects that arise with artificial intelligence algorithms versus the statistical foundations. And I think that stat foundations can enhance artificial intelligence algorithms because right now they're very dependent on the particular data on which they are developed.
Thank you. Ms. Ballou, in next-generation sequencing, algorithms known as probabilistic genome software used to interpret complex DNA mixtures. This technology is widely used in forensic labs across the country. However, it's not nearly as mature as people may think it is. What do you think the current state of maturity is of next-generation sequencing?
And from this point of view, that is still under research. We are taking a look at it. It's a new area that we're investigating, and to find exactly where we are on that particular type of project, I will get back to you with further information.
Well, it sounds like in the past, a lot of opinion has been passed on as science, and it's put a lot of innocent people in harm's way one way or another. So this is important. I appreciate the hearing. Thank you.
Thank you very much. Dr. Beard.
Thank you, Madam Chair, and thank you, witnesses, for being here today. I appreciate your sharing your information with Ms. Ballou. I'm going to start with you. My home state of Indiana has made a significant investment in technology-based programs, substance use programs, mental health treatment services for those that are incarcerated. So is NIST able to measure the impacts of state investments like this and incorporate those into the overall, your overall program? And I think you've answered some of those, but I'm going to give you another chance because I'd like to see how you feel about that. So.
That's an interesting question, and I do not believe I have additional information to provide for you at this time.
So let's try another one then,
Okay.
In my community in West Central Indiana and across the country, as we all know, fentanyl and other synthetic drugs are causing a shocking increase in the number of deaths. Could you elaborate on NIST's work on the standards and for detecting these illicit drugs?
So NIST is working on improving the current technology that is used to screen for the presence of certain drugs. Right now, we're trying to make it so that there's the smallest amount of contact between the first responder and the suspicious material. We're still working to improve the process, and we hope to get that out to the community so that they can apply it as soon as possible.
Very good. Mr. Gamette, what challenges do you face in your laboratories with analyzing illicit drugs, and what would you like to see us help you to get your work accomplished?
The challenges we see are instrumentation, which is very expensive in these disciplines, mainly toxicology and drug chemistry. It's also very expensive to train analysts in this discipline. It's expensive. NIST is providing some help on getting standard reference materials for us. That's been very helpful. So some of that research work to go into identifying panels for doing the validation study of these instruments when they come into the laboratory, that's also very helpful because it takes us a long time. What we haven't mentioned in this hearing is validation has to be done of every scientific discipline and every scientific instrument before we can use it in the laboratory. So all those things take resources to be able to do. And with the medical examiners, they're also dealing with this opioid crisis and need resources, and they also have severe workforce issues that we need to start dealing with.
Thank you very much. I appreciate and I recognize the need for standards here and being able to use those as reference material as you make comparisons. And so I think that's extremely critical. And that was more of a comment than a question. So Ms. Garcia, can you elaborate on how the Texas Commission is working on the NIST Standards Coordination Office? You've probably answered part of that. And do you have any recommendations for how NIST could better coordinate with other states or with the states?
Thank you for the question. So when I refer to the Standards Coordination Office, what I'm talking about is actually not the OSAC. It's a separate part of NIST, that interacts, helps regulators, both federal and state, to work with accrediting bodies. So all of our laboratories are accredited, but what we've seen over the last 10 years is that accreditation has great benefit, but it also misses some things. And some of those are major things. So what we're trying to do is work with that body so that they can help us set up a list of, in addition to the ISO program, these are the things that we'd like to see in Texas laboratories. And then we'll work with the accrediting bodies so that they can assess the labs against that extra list. And it could include everything from human factors considerations, all sorts of things. So that's what I meant with that comment.
Thank you. And one last, I've got about 36 seconds, I guess. So, Ms. Ballou, can you elaborate on how you prioritize the work in your forensic science? And
We prioritize our work really by listening to the experts, the forensic scientists themselves, to learn where are the issues that they're facing. And we also pay attention to what are the latest court issues that are taking place. What concerns actually happened in the courtroom? Is there somewhere that we can apply measurement science to address those issues?
3 seconds, you did very well. Thank you. I yield back.
Thank you very much. Ms. Weston.
Thank you, Madam Chair, for yielding, and thank you to the panelists for appearing today. Before I became an elected official, I'm a recovering lawyer. I served as a prosecutor, I was a criminal defense attorney, and I was even a judge for a while. So I have seen firsthand how incredibly persuasive forensic evidence is. In fact, a lot of times during voir dire, certainly in serious felony cases, I would inquire of the venire, how many of you would convict without some sort of forensic evidence, whether it be fingerprints or DNA or a certificate of analysis? And it was surprising to me, but on just about every panel, there would be some people who say, I would not convict without that information. So it works both ways. So, you know, I have seen at all different cases how we have used forensic evidence. Now, in 2005, my home state is Virginia. And in 2005, we changed the DWI statute in Virginia. We're all accustomed to the 0.08, liters percent per, by weight by volume or per 210 liters of breath. But Virginia changed our statute to have presumptive levels of cocaine, methamphetamine, MDMA, and PCP in blood for presumptive impairment. Now, that was interesting to me, so when I saw, it was before I served in the state legislature, I went to look up the legislative history and I saw that there really wasn't any. And when I spoke with members who were, present when this was passed, I asked them, what kind of scientific evidence was presented about the impairment levels with these various, milligrams of substance in the bloodstream, and nobody had any recollection of anything. So that got me thinking about, now I haven't seen any cases, by the way, being prosecuted under this particular section, but that got me thinking as we have, there are more and more states that have legalized marijuana, it is still presumptively illegal to operate a motor vehicle under the influence of marijuana in those states where it's legal. So I guess my question is kind of a two-part question. First of all, who makes the determination? How is that determined what that presumptive level of a substance would be to bring up to the level of impairment? And second, is there anything going on in the area of marijuana intoxication that NIST is involved with or any of the other state labs are involved with?
Actually, NIH had done considerable studies. We're working on it. Dr. Marilyn Hustis was lead on that. And she was looking at, what are the effects of marijuana? How does it impair different people? And we were hoping to take that information and then start working with other entities that have similar experience on determining, now we need a detection process. So NIST had worked with FIU, Florida International University, who had expertise in determining some of this relative information and trying to devise some type of, not a box, but some kind of detection instrument that would be similar to the blood alcohol that you could take in the field and have somebody breathe into. The difficulty is that the exhalation of the metabolites from the marijuana differ from person to person. So we're still at the stage of trying to figure this out and also working with the legislator as to what should that level be for impairment.
And could the level of impairment for one individual be different from another individual?
Yes, it could.
Okay, but that's like alcohol in that regard?
Yes.
Okay. How about other substances like the cocaine or MDMA or PCP?
At that time, we're not working on those particular substances, as that would have to be a blood draw, correct?
Yes.
And therefore, further work within the laboratory would take place on that. And at this time, I don't recall if NIST is involved in those particular testing procedures.
Okay. Does, Ms. Garcia, do you have anything to add about those processes?
I would just say that I don't think we have limits or detection levels in Texas on those substances. I think any presence of that in the blood is going to be grounds for potential offense. In Texas, marijuana is not legal, but the legislature just passed something similar to the federal farm bill. So right now we're working very closely with the DEA on distinguishing hemp from marijuana. But in terms of marijuana in the blood and impairment, I know from talking with our toxicologists, it's a particularly tricky issue in terms of how you set the line for impairment for operating a motor vehicle.
Very good.
So we need help from NIST.
Yeah. Thank you very much. I see my time has expired.
Thank you. Mr. Tonko.
Thank you, Chairwoman, and thank you for holding this hearing on the state of forensic science in America, and thank you to our witnesses for joining us today and your expertise shared. Chairwoman Johnson, thank you for your leadership on this issue. I fully support efforts to establish scientific standards and protocols across forensic science disciplines. DNA evidence has quickly become one of the cornerstones of justice in America. As our knowledge and technique in using this evidence improves, we need to make certain that our progress relies on credible, rigorous science. New York's 20th Congressional District, which I represent, has established itself as a home to national leaders in forensic science. The Forensic Investigation Center in Albany holds New York's DNA database, a vital resource to all who fight in the name of justice. That DNA databank has helped with more than 3,000 convictions and has exonerated some 27 innocent New Yorkers. Professor Igor Lednev at the University of Albany is working to develop new novel methods for forensic and medical diagnosis. With the help of more than a decade of continuous funding from the National Institute of Justice, he was able to develop the first universal method for characterizing biological stains at the scene of a crime, revealing the time a crime was committed and vital personal details such as age, race, and sex. This novel technology can help investigators analyze a possible crime scene much more quickly, avoid more false positives, and help reduce forensic backlogs that plague every criminal laboratory in America and ultimately speed up lengthy legal proceedings for violent crimes. Dr. Ray Wickenheiser, director of the NYSP Crime Laboratory System, together with Dr. Lednev, have proposed creating a first-of-its-kind incubator for the development and validation of such novel technologies in forensic science. This will be the first incubator in the United States based on a state police crime laboratory that brings together researchers and inventors from academia, in this case the University at Albany, with engineers from private industry. These efforts show how and where forensic science currently excels, but they should also help us address the areas of forensic science where our standards have failed to prevent grave injustices that can result from its misuse. For example, it has been common practice for experts to overstate the reliability and certainty of forensic science methods presented as fact. Juries and judges are sometimes misled into thinking expert testimony is supported by credible science even when the methods used were scientifically unreliable. This practice serves no one and leads to wrongful convictions and injustice for all. Federal government has a duty to press forward with the best science to ensure that our justice system employs those methods and eliminates the use of junk science. So My question is to you, Ms. Ballou. Throughout your career and your work at NIST and your work with the American Association of Forensic Science, you have firsthand understanding of the role of both public and private sectors in ongoing forensic science reform work. Is there a role for these types of public-private partnership in this field? And what commitments and investments could both sectors make to improving forensic science research and practice?
So I'd say our first activity from NIST in the public-private was the establishment of the OSAC, as we were able to pull in some of the private entities to provide their expertise for NIST understanding. And we hope to expand upon that to have considerably more information shared between the different variety of groups.
And how can the federal government assist in these types of partnerships like that of the New York Incubator for the development and validation of novel technologies in forensic science?
I think you've heard today a lot of examples of different ways of establishing commissions or other institutes that look at the establishments of new technology throughout these states, the local or the federal areas to expand that. So activities are already taking place. We just need more of them.
Thank you. And Mr. Gamette, have there been changes in university curricula and general approaches to education of forensic examiners over the last decade to ensure they have stronger scientific and statistical understanding?
Yes, there have been. Several of those changes have been made through FEPAC, which is a forensic education organization that is run by the American Academy of Forensic Sciences. Sorry. And I think more progress needs to be made in this area, but I think the scientists and the colleges are starting to recognize that to get jobs in a major crime laboratory, they're going to have to educate the scientists to those jobs that they're going to go into. I will also mention just briefly on what Ms. Ballou was talking about. There is a lot of work that's going on by several different groups. The Midwest Forensic Resource Center, the CSAFE that exists at NIST, in partnering the practitioners directly with the researchers, funding the research, but then making sure that they have the application of the practitioner there so that it does go into practice once the research is completed.
Thank you very much. And with that, Madam Chair, I yield back.
Thank you very much. Mr. Perlmutter.
Thanks, Madam Chair. I'm usually the last one because I always come in last. But I appreciate your testimony. Mr. Posey's letter from his sheriff made me think about the whole reason for today's hearing. And I appreciated that his sheriff wanted to see more criminal enforcement and all that sort of stuff. But we start with beyond a reasonable doubt. And where does that come from? So I actually looked it up. So you start with Abraham and Sodom and Gomorrah. The Lord didn't destroy Sodom and Gomorrah till Lot's family had escaped because he was going to favor the innocent over the guilty. Then Muhammad says, if there are any doubts in the case, then use them, for it is better for the judge to err toward leniency. Maimonides said, let 1,000 guilty go free, lest one innocent suffer. William Blackstone, at the beginning of English jurisprudence, said 10. I don't know why he reduced it from 1,000 to 10, but Benjamin Franklin, and I would refer to Benjamin Franklin and, quite frankly, John Adams before I refer to the sheriff from whatever county that is in El Paso, or in Florida. Benjamin Franklin took it to 100. He said, it is better 100 guilty persons should escape than one innocent person should suffer. And John Adams said, it is of more importance to the community that innocents should be protected than it is that the guilty should be punished. And so that's the reason for today's hearing. That's the reason we need to have our laboratories led by NIST really be as excellent as possible so that we don't convict innocent people. We lean towards allowing the guilty to go free. So, Ms. Ballou, I was at the National Water Quality Lab on Friday in Colorado, so at the Federal Center in Colorado, where they were talking about trying to detect environmental issues down to 1 part per trillion. And so from a statistics standpoint, from a scientist standpoint, how do you guys determine if something is beyond a reasonable doubt? Or is that just, we're going to leave it up to the jury?
It would help if I hit the button. I received that question when I was testifying once. Do you believe your testimony confirmed beyond a reasonable doubt? And at that time, I wasn't quite sure what that meant, beyond a reasonable doubt. And from the National Commission on Forensic Science, our Attorney General at the time determined that none of the prosecutors should be using that term, beyond a reasonable doubt, because it is uncertain exactly what it means. And therefore, we look for more towards at NIST, what is the scientific basis of a methodology or procedure? That would be our determination. And looking at the procedures that we put in place, are they scientifically solid? Is their foundation established? And from that point on, then determine to what degree can we give a response to the jurors, to the court officers of the courts as to our findings.
Anybody else? Good answer, by the way.
I would say that the importance of teaching our scientists what the limitations are of what they're saying is so critical in response to your question. If someone gets up and says, so-and-so left that bite mark to a reasonable degree of scientific certainty, and there is no data or science supporting that statement, that's how you get the trier of fact, the jury, to make the wrong conclusion on your question. So we have got to understand what our methods are. Are they valid? And NIST has got to help us with that. And what are their limitations? And how can we articulate those in a way that does not lead to an injustice?
Thank you.
I was going to say quality assurance is really important in this discussion because we don't just press for productivity, we press for quality. And that's what we want to do in the laboratory every day. We don't want somebody going to jail that shouldn't be there. Now, important in that discussion is, as it was just being discussed, uniform language in reporting, uniform language in testimony. What can the scientists say? And these standards are being established at OSAC. And it's the practitioners that are working with the researchers, with the statisticians. They all work together to be able to get this right and get it right in the courtroom.
Thank you. Anything?
I'll just say that the average person still has trouble understanding uncertainty. And so statisticians are trying to figure out ways that we can communicate not just the confidence in our results, but the limits of the uncertainty.
Okay, thank you. I yield back.
Includes all of our questioners, and let me thank all of the witnesses for being here and for your excellent testimony. The record will remain open for at least 2 weeks for additional statements from members or any additional material you'd like to submit. At this time, I will say thank you to the witnesses, and you're dismissed, and the meeting is adjourned.